everybody, it's Lacey, and welcome to another episode of the Lawmas Podcast. Unfortunately, we are apart again this week. Lauren is actually in Vegas. She went to go see the Backstreet Boys at the Sphere, and I'm extremely jealous. But again, hopping on here to do another week's episode, but I really do hope we're back to normal very soon, just with everything going on. It's been just very hectic. But today's episode, I'm actually going to cover a little bit of the appeal for Alex Murdaugh. If you're from South Carolina, you probably know all the details there is to know about this case. And honestly, if you're not from South Carolina, you probably know just as much as we do. This has just been a national case that people have followed. It was live on Court TV. Just a brief synopsis. Murdaugh was charged and convicted for murdering his wife and his son a few years ago here in South Carolina and Colleton County. He was sentenced to life in prison for those murders. There's been an appeal, of course, which is common in murder cases, I would say, especially when there is a life sentence. And they held oral arguments this week on the case. So I just kind of want to walk through that procedurally, what that means. So an appeal is when an attorney believes there are errors of law made. An error of law means that the judge made mistakes. So that's what an appeal is going to cover. So if the attorney made mistakes, that's not going to be grounds for an appeal. Grounds for an appeal is when the judge made mistakes that affected the outcome of the case. So that is what Murdaugh's attorneys have done. They have filed that appeal and raised all the mistakes that they believe that Judge Newman made during the course of the 6-week trial. The two biggest errors that they talked about in the oral arguments are the issues with the clerk of court, Becky Hill, and I'll come back to those, as well as allowing the financial crimes in as motive for the murders. And like I said, I'll come back to that. So once a trial is lost, every defendant has the right to an appeal. There's not always grounds for appeal, to be honest. I've read transcripts before where I did not find that the judge made any errors of law, where I have felt that, what came in as evidence should have come in as evidence. What was kept out should have been kept out. So sometimes there are not grounds for an appeal. Here, I definitely think there were grounds for appeal, and the strongest being the two I just mentioned. An oral argument goes and is just precisely that. It's when the attorneys get to go and argue personally, in person, in front of the panel. And here is our Supreme Court. So this appeal went straight to the Supreme Court, and that is because of our rules here in South Carolina. So the justices that sit on the panel for the Supreme Court, they get to kind of determine how much time each party gets. So they set out a time limit. You're notified well in advance of how they are going to structure the oral arguments. I had my first oral argument for the Court of Appeals a few months back. I think it was end of last year. And I think mine was 10-10-5. So I filed the appeal. So I went first. I had 10 minutes. The state had 10 minutes, and then I had a 5-minute rebuttal. During that oral argument, the judges can interject at any time and throw any question at you. It could be a question on case law, what you think the rule is and why the rule applies here. Anything and everything can be thrown at an attorney. Here, the justices did decide to allow the first 5 minutes without interruption. I really liked that structure. I thought it gave the attorneys a way to set the organization of their argument, and I felt like it flowed really well with allowing that 5 minutes. So I really liked that when I was watching it, that they allowed both sides 5 minutes without interrupting with questions. But they had the oral arguments. Dick Harpootlian was the trial attorney for Alex Murdaugh, and Attorney Waters with the Attorney General's office, Creighton Waters, he was there to argue for the state. So it was the same attorneys that you saw if you watched it on TV. And so I really felt Dick Harpootlian did a very good job opening up the oral arguments when he was talking about he discussed being in that room and upholding the Constitution, and that he really didn't know exactly what he was promising when he made that oath when becoming an attorney. And I think that's true for a lot of us. And he was talking about, but, amendments are important. The First Amendment is important. The Second Amendment is important, but nothing is more important than the right to a fair trial. And I wholeheartedly agree with that. And so I thought he started off very strong, just laying that foundation. Of course, that's stuff that the justices know, but I just think it drew you in and just helped lay the foundation for the arguments he was going to make. Because I do think the two grounds for appeal that they're really focusing on here really affected the fairness of this trial. And as he mentioned, he even talked about the Aaron Burr case, which is a very long time ago. If you watch the Hamilton, the musical, you know how long ago that case was. But he even talked about that case and how even Aaron Burr, even though it was terrible, he was afforded the right to a fair trial. Everybody get it, that no matter how heinous the crimes are, no matter how much you hate Alex Murdaugh, he is entitled to a fair trial. So, the first big issue, of course, that they talked about was Becky Hill. If you have followed the Murdaugh case, you know that Becky Hill made statements to a certain amount of jurors that may or may not have influenced the verdict of the case. And that's kind of what the Court of Appeals is determining now. So once it came forward that she had made statements to the jurors, before we even got to the appellate level, Murdaugh's attorney did file a motion for a new trial, which is the proper thing to do in this situation. I have done the same. And he did bring up allegations of jury tampering. Now, that motion for a new trial was actually heard in front of former Chief Justice on our Supreme Court, Jean Toll. And what the court was kind of saying today is they kind of struggled with former Justice Jean Toll's like picking and choosing which parts of jurors' testimonies were credible or not. So there were several statements made by Becky Hill. You can go follow some details, but she would say like, oh, make sure you're paying close attention, watch his body movement. And she made comments about, oh, he's going to testify. This hardly happens with a defendant. And at some point, I don't know how many jurors she made the comment to, but she said, now it's the defense's time and they're going to try to trick you, make sure you're watching because they're going to try to trick you, like something like that along those lines, or is what she told jurors. Which is completely improper and inappropriate. I think both attorneys acknowledged that what Becky Hill did was wrong, was extremely wrong. The difference is the defense side, so attorney Dick Harpootlian is arguing that did influence the verdict of the case, and therefore Murdaugh did not get a fair trial, and he should be ordered a new trial by the Supreme Court. And the state's argument is that these things came back much after the verdict, and it was so minimal with the amount of evidence, it did not affect the verdict, and therefore he got a fair trial. I may be biased. You can say it, take it for what it's worth. I am a defense lawyer. I've been one for 10 years plus. But I really do, like I said, you could differ. I really do think that affected it. I think it was Justice Few said in the oral arguments that in the courtroom, you had such a great, professional, intelligent attorney general. You had the same thing on the defense side. You had the same thing in a judge, and you had a rogue clerk in the back roaming the hallways. I think they made a good point too, saying that Becky Hill was the one that interacted with the jurors the most. She was the one that led them to the jury box, led them out. She was the one that they saw the most out of everybody in a closer relationship than the lawyers. And even Justice Few even said, just called her flat out a liar. I mean, they were saying that she was untruthful, she was not credible, and Justice Few, it's like, let's call it what it is. She's a liar. So they went through the improper comments that she made to the jury. I felt like they were really on the defense's side that this was improper and had major concerns about the fairness of the trial because of what Becky Hill did. I don't believe that they liked that Justice Toll, when she had the motion for a new trial, like I mentioned, she was picking and choosing which parts she believed to be credible from the jury. So basically, like, they had certain jurors testify. They had one affidavit. She found certain pieces like, oh, I believe this juror when they say this, but I don't believe them when they say that. I don't think they really liked that. Either the juror was credible and you believed their statement, or you did not believe their statement and did not find them credible. It really appeared to me they didn't like that she pick and chose when denying the motion for a new trial. So that was the first big issue that they discussed. And like I said, I really felt like they just hit Creighton Waters with a ton of questions on the issues with that. And it really, to me, seemed like they had big concerns over the fairness of the trial because of Becky Hill and what she did. The other thing, of course, is the financial crimes. So he has pled guilty and he's been convicted clearly from that plea of stealing millions of dollars from prior clients. And any attorney watching knew that this was going to be an issue on appeal. During the whole trial watching it, we knew this was going to be the biggest issue on appeal until we found out about the Becky Hill stuff. So that was what the state introduced as motive. We have rules of evidence that we have to follow. And it's, sometimes the defense and the prosecutors disagree on that rule, whether something should come in as evidence and what should not. And the judge gets to determine whether it comes in. Some things is relevancy. Is this piece of evidence relevant? That's one thing that a judge looks at. Here, the rule that's going to apply is were the financial crimes more prejudicial than probative? And what that means is, are they more hurtful or helpful? And so really just trying to balance the fairness of letting something in. So here, the financial crimes, they introduced that as motive as to what led to the murders. And again, I think the justices really had concerns over what was allowed in with the financial crimes. They really struggled with how that was a motive. And one justice said that they just had a lot of difficulty tying together the financial crimes to the murders. They didn't really get the link. In addition, I think they were saying that even if they came in, it kind of felt like they were saying that the state took it too far and went into more of a victim impact and trying to make the jury feel bad for these people and hate Murdaugh, which is just not appropriate. Victim impact cannot come in during the trial phase. It can come in during the sentencing phase, but not the trial phase. And so that was another thing that, of course, was the issue on appeal, the second big one that we all knew was coming. And it did to me seem like the justices were really concerned about how far the financial crimes went. I don't know if they're going to come back and say that none of it should have come in at all, or that maybe it should have been more limited in its use by the state when it was coming in and that it went too far. So all of that, those were the big issues with the oral arguments. I'm very curious in how it's going to come out. I did not watch the whole trial. I'm too busy with 2 kids, my practice of my own, and running my own business. It's just not something I had time to do. So I missed a good bit. Of course, I know the big highlights, but I'm just such a nerd for the law. It's these appellate issues that I'm really interested in. So I'm just very curious as to what the Supreme Court justices are going to do. My friend Lori Murray, Lawyer Lori, plugging her for her TikTok, she came out and she said that she would be shocked if he didn't get a new trial. She would put money on the fact that he is going to get a new trial after watching these oral arguments. I think I saw something from Erin Bailey that she kind of felt the same way, that it seemed like a slam dunk that they were going to give Murdaugh a new trial. I kind of felt the same way with how they threw question after question to the to Attorney Waters. Now, my mother-in-law, I must say, she felt like Hartpoulian did not do a very good job. She felt he was stammering. She felt like the state had stronger arguments. And so I don't know where she leans. I didn't finish that conversation, but I know that she kind of felt differently than us. So I'm curious what y'all's thoughts are if you watched the oral argument. If you didn't and you're listening to my summary, let me know what you think, about these issues, or if you have questions about appeals or something, like hit us up and let us know. So, I don't know how long it's going to be. Clearly they are going to go back and review everything, review the case law, review what was said during the oral arguments, discuss with each other, and then they will take a vote, and then, they will draft, a decision with the ruling. So, that could take a few months, that could take a few weeks. It just really depends. So there's no time frame on it, but as soon as I get it and am able to read it, I'll definitely give an update on what happens. So keep following us for any updates on the Murdaugh trial. And that wraps up this week's episode. Again, I hope me and Lauren are back together next week, but if not, we will be. It's just a matter of scheduling and everything that happened with the storm and stuff on Lauren's side. And my son has just had some extra appointments and stuff, which he typically does at the beginning of the year. So it just might be crazy at the beginning of the year for us in the future. But I hope everybody has a nice and safe weekend, and we will see you next week. Thank you.